The two Duke University students arrested on rape charges Tuesday are free on $400,000 bail each. 20-year-old Reed Seligman and 19-year-old Colin Finnerty are both sophomores and members of the school's lacrosse team. A third, as yet unidentified player, may also face charges. Joining us with some answers to the many questions surrounding this case and the newest developments is CBS News legal analyst Andrew Cohen. Good morning.
Good morning.
Now that they've been indicted and arrested, what can we read into this?
Well, obviously, the grand jury felt that there was probable cause to think that a crime has been committed. That means that the grand jury and the prosecutors believe it's more likely than not that these two young men committed a crime. They committed the crime of aggravated rape and kidnapping and sexual assault. Long way from proving their case beyond a reasonable doubt. The burdens of proof and persuasion are very different, but this is how a criminal case starts.
We live in a CSI world these days, and now that there has been no DNA evidence found linking them to the alleged victim, how can the prosecution go forward?
Well, see, I sort of take all that with a grain of salt. I'm not convinced that there isn't any DNA. I mean, the defense attorneys have said there was no match. The prosecutor has said that there may have been other testing of other samples to match with the players. I don't think we've heard the end of that DNA story. And even if we have, and even if there is no DNA link, everyone knows that DNA is very persuasive as evidence. Jurors believe it because of the scientific accuracy of it. You can have a successful rape conviction, a successful rape case as a prosecutor without DNA evidence. You have it with physical evidence, with eyewitness testimony. We know from the prosecutor that the alleged victim showed trauma consistent with a sexual assault. Those are the sorts of things that you can use to piece together a case without DNA. DNA is sort of the home run of it all, but you can piece together a case without it, and that's what this prosecutor may have to do.
Is it common to go forward without DNA evidence?
I think it is. I don't think it's as common as it used to be. I mean, DNA hasn't been around forever. There are plenty of successful prosecutions before it. If you're a prosecutor and you can make that link, well, you really have a great case because it's awfully difficult to explain away the DNA connection between an alleged victim and a suspect and a defendant. But that's just one component of this case. There are going to be other components, physical evidence, there are going to be eyewitnesses, there's this timeline, there's this alcohol factor. I mean, there are a lot of issues in this case. If you were in law school and you were drawing up a scenario of a convoluted set of facts and a convoluted legal scenario, this would be it in a rape case. You have a lot of people involved, all the players at the party, you have drinking involved, you have the young people, you have sex, you have different accounts and so forth. It's going to be a very complicated case.
The prosecution basically runs the show when it comes to the grand jury. How does that affect the defense?
Well, when you're the defense in a case and you know your guy's a target, there's nothing you can do. The grand jury process is supposed to be a prosecution-only show. You get no cross-examination as a defense attorney. You can't bring in your own witnesses. It's basically one side of the story. And it's the grand jury looking at the government's evidence, the prosecution's evidence, and saying, okay, we're going to allow this case to go forward. We're going to let you go to trial, and then you're going to have to test your evidence. In this case, I think what happened was the prosecutor, up for re-election, figured, you know what, I'm a little shaky about this. I'm going to send it to a grand jury. I'm going to allow the grand jurors also to evaluate the evidence. If they like it, if they agree with me on the impact of this evidence, they're going to find probable cause. They're going to give me a buffer. I'm going to be able to say to people later, hey, look, the grand jury agreed with me, and that's why I brought the case. So he's got a little bit of insulation now going forward, but pretty soon he's going to have to establish a little bit of his case, and he's going to have to, I think, answer a lot of these questions that defense attorneys are raising about the timeline and about the victim, the alleged victim's credibility and so forth. Those are questions that a lot of people have and a lot of people in that area have, and of course those are the people who ultimately will be jurors in the case.
Switching gears and moving to the Enron trial now, the prosecution squared off with Jeffrey Skilling. How are they doing?
Well, I think it has not been as dramatic as a lot of people thought. You know, Jeffrey Skilling's this bright guy, this energetic guy, this guy who's not used to sitting there and answering questions. And yet the prosecutor has asked him over and over again, hundreds and hundreds of questions. No home runs, no grand Perry Mason moments where, you know, Skilling breaks down and confesses to everything. But I think prosecutors have been effective in getting little points, hundreds and hundreds of little points about how Skilling's story, in the prosecution's view, diverges from the story that other Enron witnesses have told. And the essential story from the government's perspective is Skilling had to have known that there was fraud at his company. He had to have been involved because he was the mastermind of it all. And it's inconceivable that all this bad stuff would have been happening without his knowledge. What he's saying is, I wasn't that involved. I didn't know everything that was going on. I didn't think there was a need for fraud. I never would have condoned it. Ultimately, jurors are going to have to decide whether he's telling the truth or not. And if they don't believe him, he's going to be in big trouble, and so is Ken Lay.
And finally, I just want to touch on the Moussaoui trial.
Right.
That got delayed. We did hear Moussaoui leave court on Tuesday, and he said, crazy or not, what am I?
Right.
That kind of captured the day.
Yeah, I mean, it was a very dramatic day for the defense. You essentially have these experts coming in and saying that Moussaoui is schizophrenic and paranoid and so forth, and he really isn't in touch with reality. Ultimately, I don't think that's going to matter. I think the jurors would probably agree, based on what they've seen of Moussaoui in court, that he's not, dealing with a full deck. I don't think it's going to matter when they have to make their life and death decision. I think they're going to base him on what they think his role was in 9/11 and what they think the worst punishment is going to be. And I am still not convinced, when closing arguments begin next Monday, that jurors ultimately are going to all vote for death. I think a couple of them may say, you know what, the worst punishment, life in prison, send him away.
All right, we'll have to wait and see. Thank you
Absolutely.
so much.
My
CBS
pleasure.
News legal analyst Andrew Cohen, thanks for being with us.
My pleasure.